introduce the Francis Biddle Memorial Lecture and to welcome Sherrilyn Ifill, the President and Director-counsel Emeritus of the NAACP Legal Defense Fund. So let's please give her a big. She will present a lecture entitled Leave No Power on the Table. And we are so proud to have President Emerita Ifill here today. She is one of the great civil rights leaders of our time, and I know that we will learn from her and find inspiration in her remarks today. I'll shortly turn things over to my colleague, Professor Guy Orville-Charles, who will moderate today's lecture and say a bit more about our distinguished speaker. But before I do, I want to say a few words about the Biddle Lecture and about Professor Charles, who with great wisdom selects our Biddle lecturers. So first about the lecture, Francis Biddle was a 1911 graduate of Harvard Law School. He was a law clerk to Justice Holmes and went on to serve as Attorney General and was a U.S. member of the International Military Tribunal at Nuremberg. The Biddle Lectures arose out of a gift from his widow, Catherine Biddle, who asked that the selection of our lectures reflect, quote, that civil liberties and civil rights were of particular concern to my husband and thus particularly appropriate areas for lectures, end quote. I can think of no one who will better fulfill the purpose of this lecture series than our speaker today. And before turning it over to Professor Charles, I just want to say a few quick words about him, about my wonderful colleague. Professor Charles, the Charles J. Ogilvie Jr. Professor of Law and Faculty Director of the Charles Hampton Houston Institute for Race and Justice, is a creative and path-breaking scholar whose writing has reimagined the critical relationship among voting rights, race, and democracy in America. Professor Charles joined the faculty in the summer of 2021 and in 2 short years has become a central figure in the life of the law school, giving generously of his time and talent to teach and mentor our students and to advance important initiatives that make this law school and the world better. Let me turn things over now to my dear friend and colleague, Guy Orville-Charles.
Thank you so much, Sir John. It's always a pleasure to follow him and to be part of this community where he is the intellectual, academic, and everything leader. Absolutely a pleasure. So how does one introduce an icon? How does one introduce a living legend? How does one introduce, really, as Dean Manning said, one of the greatest civil rights lawyers, thinkers, intellectuals of our time? Sherrilyn Ifill began her career as a fellow at the American Civil Liberties Union before joining the staff of LDF as an assistant counsel in 1988, where she litigated voting rights cases for 5 years. She left LDF to join the faculty at the University of Maryland. I always want to think about her as Professor Ifill, but that would really be to denigrate everything and all that she is and all that she's accomplished. But it is the first place where I encountered her as the civil rights and voting rights legend. Over 20 years, she taught, like all really good people do, civil procedure. Deigned to also teach con law to thousands of students, pioneered a series of law clinics, including one of the earliest law clinics in the country focused on challenging legal barriers to the reentry of ex-offenders and reparations. From 2013 to 2022, she served as president and director-counsel of the NAACP Legal Defense and Education Fund, the nation's premier civil rights organization. She took leadership of that fabled organization and proceeded to lead it through its greatest area of growth. When she was first announced as the director, counsel, and president of that institution, I think so many of us thought there is nobody in this moment in time who can do the job, what is necessary to do with LDF as Sherrilyn Ifill, and there is no doubt that all of us were proved right and prophetic. She renewed its intellectual mission. She placed it once more at the center of legal fights for voting rights, criminal justice, and economic equality. And at the time when the country needed it the most, she and LDF served as the moral conscience of this country, particularly as we struggled through the killing of unarmed men, black men, at the hands of the police. It was her voice that served as our conscience, calling us to action, compelling us to try to do better. She not only led LDF superbly, she also secured the organization's immediate future by mentoring a worthy successor, a person who is qualified to wear that mantle, Janae Nelson, another luminary of the voting rights bar and academic superstar. Sherrilyn Ifill is not just a prolific scholar, she's definitely that. She's published scores of academic articles in leading journals. She's also a true public intellectual. She's a sought-after and perceptive public commentator who has written and published op-eds and commentaries in leading newspapers. She regularly appears on television and on the radio to think and talk about the important issues of the day, and she does so with not just a prophetic and compelling voice, but with significant intelligence as well as compassion. Her 2008 book on the courthouse lawn, Confronting the Legacy of Lynching in the 21st Century, was not just highly acclaimed, it is also credited with laying the foundation for contemporary conversations about lynching and reconciliation. It showcases her intellectual dexterity and her moral conscience, as well as her deep intelligence. Few, and truly that is the case, few has been as impactful in the past decade in shaping the national conversation about race and civil rights as Sherrilyn Ifill. Indeed, I can't think of anybody else who has been as impactful as she has. She's a graduate of Vassar College with a BA in English. She earned her JD from NYU. She's the recipient of numerous honorary doctorates and was named by Time magazine as one of the most 100 influential people in the world. There you have it. She's the recipient of the Radcliffe Medal, the Brandeis Medal, the Thurgood Marshall Award of the American Bar Association, the Gold Medal from the New York State Bar Association. She served on President Biden's Presidential Commission on the Supreme Court. She's currently the Senior Fellow at the Ford Foundation. But today, she is our Francis Biddle Lecturer. Please join me in welcoming our distinguished speaker, Sherrilyn Ifill, for her talk, Leave No Power on the Table.
When I do things like this, I have in my mind's eye how wonderful it was to see a room of packed people, but make sure I didn't have a photograph. Thank you so much. Thank you to the dean, and thank you, and thank you, everyone, for coming to this talk. I'm actually really thrilled to be here today, and I had no idea I would see so many friends from my days at LDF and from the Academy and board service, and it's wonderful to see all of you today. Hi, Victor. Hi. Hey. Oh my God. Marshall Motley Scholars. One of the greatest, I think, accomplishments before I left LDF was with Janae launching the Marshall Motley Scholars, which is preparing the next generation of civil rights lawyers and raising the money so that we pay for your whole ride in law school and fellowships in the summer and 2-year fellowships when you graduate, with a commitment to working in the South. And it's just wonderful to walk into rooms at law schools and see some of our first class of Marshall Motley Scholars. So, oh, that warms my heart. The reason I'm happy I'm here today is I've been doing a little bit of a tour. Just a couple days ago, I was at Princeton Theological Seminary and had a great opportunity to talk, as I have wanted to do, about the role of the faith community in this moment in our country. And although my talk today is entitled Leave No Power on the Table, I decided I really should take advantage of the opportunity with this particular audience and in this space to have you help me think through the issues that I am really grappling with at this moment in my writing and in my thinking, which is about our profession and who we are in this moment. I was sharing earlier that I'm going to take the mystery out of it. I think we are in a moment of democratic crisis in this country. I know we are in a moment of democratic crisis in this country. And I worry and fear that far too many of us may believe that this crisis cannot deepen, and that we may emerge from this not a democracy. And so because I think it's a time of emergency, I have been really grappling with my own role, the role of those of us who believe in democracy, believe in equality, believe in justice. What is our role at a moment of this kind of democratic unraveling? So I'm writing a book, and the book is called Is This America? And the book, in its first part, tries to describe how we came to this moment, and particularly the role of race and racism and white supremacy in bringing us to this moment. And the second half of the book is about what we do, hopefully on the other side. The reason I'm writing the book is, first of all, I think it is critical that I fulfill the job of the civil rights lawyer, which is, in my view, not just to show up in court and litigate, not just to argue in the courts of appeals and in the Supreme Court, not just to represent our clients in their communities, but to actually be the person and the persons who are able to discern the scaffolding of injustice in our society. That is, to be able to understand how the pieces fit together, the joints. Not just the individual instances of injustice, but the overall framework that holds it together. And so to be a civil rights lawyer is, at least in my view, deep intellectual work, because we are supposed to know things, we are supposed to see and discern things, and our experience exposes us to the infrastructure of injustice. So I'm writing the book in the first part to talk about that infrastructure, to talk about whose voices we have failed to listen to, and how those voices had important information for us about critical weaknesses in our democracy that have now been more fully revealed. That's the first part of the book. But I want to talk a little bit about the second part of the book. The second part of the book is about the work of making a healthy democracy. For my lifetime, and I think perhaps forever in the history of this nation, we have been an unhealthy democracy. I know this because of what Professor Charles was just talking about, which is if you watched film on the news consistently and you saw officers of the state executing racial minorities who were unarmed over and over again, you would think that that country had a democracy problem. When you see people standing on line to vote for 9 hours, you think, well, they may be a democracy, but obviously they're not quite healthy. When you see disparities between the very wealthy and the very poor, you know that there is something not healthy in the democracy. Now, I give a lot of leeway to this country because I consider us a very young democracy, and some of you have heard me say this. I certainly don't count as a real democracy before 1954 because I don't believe you can call yourself a democracy if half the country is governed by legal apartheid. So that's 54. I might take it to 65 when the Voting Rights Act was enacted, allowing most black people in this country for the first time to have an opportunity to participate in the political process. So we're a young democracy. And so I give us some leeway because we're still figuring it out. We're maybe 58 years in. But it's also true that democracy is a fragile thing. It is not permanent. It requires our work, our vigilance, our determination, and our intentionality about not only holding on to the framework of a democracy, but about continuously strengthening ourselves and making ourselves healthy. This moment that we're in is one in which we genuinely face the possibility of losing democracy even in the framework that we would expect in most places. But I think the challenge for us is, even if we survive this moment as a democracy, how do we make ourselves healthy? How do we make ourselves well? What do we do to become the kind of democracy that is resilient and cannot be as easily unraveled as so much of our democratic infrastructure has been unraveled over the past 7 years? One particular focus of my inquiry is about institutions. Institutions are critical to democratic strength and health. And even though they are often fashionable to critique, and appropriately so, they nevertheless are essential as building blocks of a democracy. And in my view, some of the most important core institutions of any healthy democracy have revealed themselves in our country to be weak. We have seen flaws in them that are deeply alarming, but also are calls to action. If you have a home and a pipe bursts, that's a terrible thing. You don't want that to happen. But when it does happen and you go in to investigate, you often discover other weaknesses in the system. And sometimes you're even thankful. If that pipe hadn't burst, we wouldn't have learned that, right? So I actually think the revelation of the weaknesses we see in our democratic institutions are welcome opportunities for us to do the work that you would do in your home, right? Which is to figure out how to make it well, to bring in the right people, to first make sure you have the right diagnosis, and then to figure out how you fix the problem. Sometimes you can patch the existing infrastructure, and sometimes you have to tear it out and create something new. Sometimes you discover that there are new ways of doing things. That means that even though you don't have to create a whole new infrastructure, you're going to do it because nobody does that anymore. Nobody uses that material anymore. Sometimes it's just a refreshing. And so I think that's what we're due for. And as I said, I was at Princeton Theological Seminary because one of the institutions that I think has failed us, and without which our democracy at least is not likely to become healthy, are faith institutions, who have not only, in my view, failed, are actively engaged in many instances in the further unraveling of our democratic values and understandings with one another. And so I wanted to talk with folks at Princeton, but I've also been talking to other faith leaders about what their obligations are in this moment. If you hear prominent members of Congress declaring that this nation is one led by white Christian nationalism, what is your obligation as a faith leader? And why aren't we hearing those voices? And of course, I also make the same demand of media, which is another institution which I think has failed us and is due for forensic and also is due for change. That we actually made it through 2016 without the media deciding in the subsequent years that it would take a look at itself and figure out what it had done right and what it had done wrong and what needed to change, and a deep inquiry into the meaning of objectivity and understanding, why do we hesitate to use the word lie when we know it's a lie? Why do we hesitate to use the word racism when we know it's racism? Have we participated in creating a world in which nothing has meaning? Who are we in relationship to the democracy, and do we have obligations to the democracy? I've raised this with the business community as well. What does it mean to be a fiduciary? And what does it mean to be a good corporate citizen? What are the obligations of corporations who have been granted by the Supreme Court personhood under that most important provision of our Constitution, the 14th Amendment? An amendment created to ensure the first-class citizenship of Black people. but that has been gifted to corporations to be able to vindicate their desires and rights. Is there a reciprocal obligation that is fiduciary? Or is their only obligation to maximize profits for shareholders? In other words, if you are a board member, let's say, of a corporation that, in which billions of people communicate, that has become a huge communication platform across the world, and that is so powerful that nations try to influence and incite violence and stir up dissension and change the outcome of elections, is your only obligation when you decide to sell that platform that you can get a good return for your shareholders? Would you have any obligation to ensure that the owner of that platform will conduct that platform in a way that serves democracy? Or can you just be agnostic about it because you have fulfilled your fiduciary obligation to the shareholders? But of course, it's no good to go around throwing stones at other people if you are not prepared to engage in this work in your own house. And so a lot of my concern is about our own profession and who we are in this moment. And it's a genuine conundrum, one that we will have to grapple with as things get worse, if they get worse. And I think they will get worse, certainly before they get better. Who we are in this space. I'm a bit of a traditionalist when it comes to the profession. I take the oath quite seriously. It's kind of what makes it good to be in a profession. And certainly Professor Jenkins knows this from our days at LDF. You know, when I would litigate cases in Texas and we would finish the trial, I always remember, you know, there would be, usually we're suing the state, and there would be an attorney for the state, the AG's office, and the trial was conducted, and it usually was conducted well and efficiently and respectfully. We would shake hands at the end of the trial. And I remember that my clients would say, "How could you shake hands with him? You know, he's so terrible." And I would say, actually, I don't know whether he's terrible or not. You know, he's enrolled, and I'm enrolled. And we're both members of this profession, and he's been respectful, and we had a good trial, right? And that's what that handshake meant. You know, it was professional to professional. That doesn't happen now, in part because the trials are quite different, and the allegations and the behavior is quite different. Sometimes it can happen after an oral argument, but often it doesn't. But I always liked the idea of being in a profession. I was raised with and believed that the adversarial process has unique benefits. And it's why I taught civil procedure for 20 years. I believed ensuring that my students had the secret sauce and could work the rules. You know, I used to always say, your job is not to speak. As Professor Jenkins knows, your clients are so much more eloquent than you are, and they are the experts about how power is wielded in the communities where they live. Your job is to get them to the place where they get to tell their story, is to survive the motions to dismiss and the motions for summary judgment and the motions in limine, and to ensure that you have prepared them properly and that you're ready for every objection, and to make sure they have that moment. And most often, what our clients will tell us, whether we win or whether we lose, and I will say at trial at LTF, we most often win. They will say that what was most powerful to them was having this moment where finally, at long last, everyone had to listen to them and no one interrupted them. And they had the chance to tell their story, and they were able to hold the room and feel heard. And that is value and matters as much as the one loss column. So I believed in this process, but I wonder if we're not facing a moment in which we have to interrogate, you know, as law professors even, what we are teaching law students about the adversarial process. How much does it matter? How much is it respected in our profession? I think many of the actions taken by the Supreme Court, for example, increasingly show a lack of respect for what it takes to put together a trial, for a trial record, which I was always taught was, vitally important. I've always said you don't even know if you're a good trial lawyer until you take your case on appeal and realize all the mistakes you made. And you look at the record, does the Supreme Court respect the record and the findings below? Or can the Supreme Court blow through them without good reason? I think we have to begin to ask ourselves whether we want to make a stand about the adversarial process or whether we're just okay with it no longer mattering. And this has been going on for a long time. The lessening of trials in our system. I mean, when the 3 decisions on summary judgment, were decided in 1984, we thought it was, the end of trials. And yet, here we are. But we're seeing that steady drumbeat. I'm deeply concerned about a profession in which we see rules changing depending on the nature of the case, whether they're rules of standing, all kinds of rules, not just the substantive issues, rules of stare decisis. Everyone can see it. And so it's perfectly fine to talk about the legitimacy of the court, which I think is an entirely appropriate subject to talk about. But we have to talk about our own legitimacy and the legitimacy of our profession. We have to talk about the legitimacy of our profession and what we do and the oath we take and the way in which we get our professional status from this profession, because you and I both know that every week we go on social media or open the newspaper and there's yet another story of a man, usually a black man, who's been released from prison after 25 years for a crime he didn't commit. Big celebration, cheers, smiles, hugs, feel good local news story. Is it? It condemns us. And yet we just keep it moving. There was just one this week. We just keep it moving, you and I, in our profession, in the profession from which we take our professional status. A profession that we know somehow participates in a system that allows not one-offs, but consistently the stealing of the entire lives of black men. And then just kind of like a my bad. Are we okay with that? Don't we have a crisis of legitimacy and not just the court? When we see lawyers stand up in court and make misrepresentations to the court, I think my clients are the best people in the world, deserve to win every time, are the noblest people in this country. That's not going to stop me from fulfilling my oath. I'm not going to make misrepresentations to the court. I'm not going to make allegations that I don't know to be true or that I don't have reason to know are true. I'm simply not going to do those things because I am in a profession. And we have rules, ethical rules about how we conduct ourselves. I mean, you don't know how many tweets I, during my years leading LDF, would send to our general counsel to say, can I say this about the case? Right? If it's before it's gone to trial, I got to be really careful, right? I don't want, right? I mean, you think I'm just tweeting? No, I'm still, even as I'm trying to inform and educate the public, saying, is this one on the line? If it's on the line, let me pull it. No point putting it up there. That's what I'm doing. But other people are releasing the Kraken and standing before courts and saying things that they know are not true, and saying things to the public on the public airwaves that they know are not true. Professor Charles correctly pointed out that we did a lot of work around policing and police violence when I was leading LDF. And one of the reasons that I thought it was important is for the reasons I've already stated, that I think state violence in our name, people that we provide with a gun and a taser and pepper spray and a nightstick and a shield of honor and the right to take life, we do give them that power. That when they do it in this way indiscriminately, it is a sign of something truly terrible and sinister. And, but it's a fraught area, and it's an area that Black people have dealt with for more than a century. It was the one key element of the civil rights movement that did not get a piece of legislation, right? So we got, beginning with the Civil Rights Act of 1957, we got a division in the Department of Justice to focus on civil rights. We got the 1964 Civil Rights Act, public accommodations, and Title VI, and we got the 1965 Voting Rights Act. We finally got the Fair Housing Act of 1968, passed a week after Martin Luther King was assassinated by one vote. But what we didn't get was anything related to the issue of police violence, even though police violence was well known to be a key and critical issue. The killing of Jimmy Lee Jackson by a state trooper in Alabama is what even set off the plan to march to Montgomery. And who were the people who beat the marchers on the Edmund Pettus Bridge? State troopers. We understood that law enforcement was a key part of this. Who took Rosa Parks off the bus? A citizen? No, the sheriff. You know the name Bull Connor for a reason. There was a law enforcement problem, and most of the unrest that we saw in northern cities in 1966, in 1967, and 1968, the trigger for most of those incidents across cities, 150 different incidents in those years, were triggered by some act of police violence against a Black person. So it was very much an issue. And of course, the Kerner Commission report made clear that this was a central issue. So this is not a new issue, and I thought it was important to deal with it, but I understand that it's fraught. And so what it meant for me to be able to comment in real time, to be able to appear on television, was that I had to be sure that I knew what I was talking about. And that meant that when someone was killed, that I didn't just stand in front of the camera and say, you know, and holler out my outrage, right? That at one point I said, you know, LDF needed the tagline, #2 on the scene, right? Because sometimes we weren't #1, because I needed to know, I needed to see the police report and know what the officer said happened. I needed to know who the officers were. If I could find out, you know, anything about the disciplinary record of the officer, I needed to know, had the Department of Justice ever done a pattern and practice investigation? I needed to talk with people in the community there so that I could know that I wasn't kind of speaking out of turn. I needed to connect with local leaders. And then I needed to watch that video, not once, but over and over again from every angle I could find, from people sending videos, from social media, everywhere. That was not fun. That was not fun. But what I did believe was that it was important for me, as the leader of LDF and as a lawyer, that if I show up on television, right, I'm not a civil rights activist, I'm a lawyer, that you, the public, has the right to expect that what I'm saying is something I can stand behind, that I believe to be true, that is not just my emotion. I felt it was important to show emotion, but most importantly, to be trusted as a lawyer. So when people are releasing the Kraken and I'm doing that, I have a problem. And I'm asking us who we intend to be in this process. What does the rule of law mean in this process? Listen, when federal officials, when the U.S. attorney wants to prosecute someone they believe is a gangbanger in Baltimore, where I live, and has texts or other social media posts in which that person has their colleague saying, you know, he reads the transcripts, and we just know that you're going to be loyal to the big man. I know you're going to say the right thing. We know you're on the team. They know exactly what that means. They have no problem understanding what witness tampering is. when they put out a post and say the night before someone's testimony, someone should look into his father-in-law. We know what intimidation is. We know what witness tampering is, we know what obstruction is, and every day those things are prosecuted in places like Baltimore. And yet, when the president or a high government official does it, we wring our hands and ask ourselves, well, did he really, really mean that? He didn't say the name, was it targeted? So are we talking about the rule of law or are we not talking about the rule of law? The privilege I've had is I've run a nonpartisan organization for a very long time. And therefore I don't come at it from the partisan lens. I'm old enough to have sued Democrats. And we sued Governor Clinton in voting rights cases when I was a young lawyer at LDF. We just sued Belle Edwards 2 years ago in Louisiana around voting. So I don't come to it with the partisan lens. Although I am very clear that at this moment, there is one party that is trying to unravel democracy, and I will not stop myself from saying that on the ground that it is partisan. LDF is an organization that has always had support across the spectrum, as the Voting Rights Act has always been until 2013, a piece of legislation that was overwhelmingly supported by both political parties. So we haven't moved. If one party's moved, that's their problem, and I'm not going to not talk about it because they've moved. Because I still have to believe in core civil rights and democracy. And I raise that because I think we will face a conundrum, and we saw this in South Africa during apartheid, and we saw it in Nazi Germany. There were judges in Nazi Germany who deeply opposed, and please don't the tagline, Sherrilyn says Republicans are Nazis. That's not what I'm really now talking about us as lawyers and us being able to understand what the parameters of this thing is and deal with the moral and ethical questions that we're going to be faced with. There were judges during the Nazi regime who opposed the Nazi regime, who virulently, not publicly, but believed that these were terrible people. But they also believed that to not apply the law would mean that they had also become anti-democratic, and that they thought that holding to the idea that judges apply the rule of law was important to hold for the country. Except the laws that were being passed, as you and I know, were not just. So these are questions. The same was true in apartheid South Africa, where there were judges who did oppose apartheid, at least they said, and yet felt that they could not contribute to the anti-democratic nature of that country by being judges who didn't follow the law. So lest you think that there are not ways in which, even at the very farthest end, people don't believe themselves to be ethically compromised or ethically in a conundrum. And my suggestion is that we start now, as lawyers and as a profession, figuring out who we are going to be and who we are. The Supreme Court is one thing, for sure, and there are many problems with that, and I'm happy to talk about that in our Q&A. But I also think that it's very comfortable not to focus on ourselves. The criminal justice system alone belies that the only problem is with the Supreme Court, although they have contributed in some of their rulings to the ability to continue in a system that has such profound injustices in it. But there are other reasons. And more importantly, we are not lifting our voices in the way I would expect. Finally, I have a piece in Slate today that talks about this a little bit, about the move to take power away from prosecutors and other elected officials, which I thought would have, the National Association of District Attorneys howling. How is that the rule of law, that when we don't like who you prosecute, we're going to take your power away from you? And this has been going on for some time, targeting mostly black women prosecutors. But that's not concerning to us. I'm not a prosecutor, I'm on the other side, and I'm concerned. Is that what we're saying? That when we don't like who you prosecute, we will take all felony cases away from you, or we'll be able to just remove you from office? Or does that sound like a healthy legal system and a healthy democracy? So finally, the name of the book is called Is This America? And no, it's not finished yet, and don't ask me if it's finished, just say, how's it going? Because it's very triggering. But the name is taken from the question that the great voting rights activist Fannie Lou Hamer asked, rhetorically, of course, before the Credentials Committee at the Democratic National Convention in 1964. And I'm sure you all know who Fannie Lou Hamer is. If you don't, please don't let on, because that's embarrassing. Just Google her and learn. Really one of the great, I think, mothers of our democracy, and an ordinary woman, a sharecropper, not in great health, born and raised in Mississippi, working on plantations, who became a voting rights activist. And her voice, her singing voice, but her voice in general was incredibly powerful and authentic. And fortunately, the great Bob Moses had the humility to understand that she needed her platform. She arrived in Atlantic City with the Mississippi Freedom Democratic Party, which was created by blacks and whites in Mississippi to challenge the regular delegation to the Democratic Convention. The regular delegation from Mississippi to the Democratic Convention was all white and did not allow black people to participate. The Mississippi Freedom Democratic Party followed all of the rules and was multiracial. And so they boarded buses from Mississippi, came to Atlantic City in 1964 in August to say we should be seated as the appropriate delegation from Mississippi because we followed all the rules, and they obviously didn't, since they are following a rule that obviously is at odds with the Constitution in terms of keeping black people out. It was fraught. The Democrats, and particularly the president, Lyndon Johnson, who was running for election, he was serving the unexpired term of President Kennedy, who'd been assassinated, wanted everything to go smoothly. And so there was a real conundrum within the Democratic Party about what to do. And Mrs. Hamer was allowed to speak before the Credentials Committee. And it was an incredibly powerful speech and moment. And the question she asked was, is this America? As she described her experiences. And it was, of course, a rhetorical question, but she asked it repeatedly. Is this America, the land of the free and the home of the brave, where we're beaten just because we want to register to vote? And she had been savagely beaten in Indianola by a sheriff for trying to register to vote, and her health after that was never the same. Is this America, where we have to sleep with our phones off the hook because people call us all night threatening us? Is this America? Is this America? And it was so powerful that Lyndon Johnson was so distressed that he hastily convened his own press conference so that the cameras would come away from Mrs. Hamer. For me, the reason the question is so powerful is because this very ordinary sharecropping black woman asking that question rhetorically is the implication is clear. What is it that she knows about America that these very fine people sitting in that room did not know or purported not to know? And for me, that question raises precisely the issue I'm raising in this book. Whose voices are we listening to? If you want to know what the weaknesses in your democracy are, how do you find out what they are? You listen to the people who confront those weaknesses most readily. And those are the people who are most marginalized in our country, the clients I've been privileged to serve for 30 years. And they are not the people that you will see on Sunday morning news shows, and you will often not see them in the newspapers. But they know something about this country, and they knew it before we knew it. And now we're here. And now we're at a moment of crisis because we failed to listen to those voices. And so I'm hoping in this book to talk a little bit about that first and foremost, the lessons that we missed, the voices who know something, and then talk about how we build a healthy democracy. And I hope I'll have a chance to talk with you all about our own profession and who we are in this moment and what we need to do to be contributors to democracy and not bystanders. So, thank you.
All right, I know that some of our students are going to have to get ready to go to class. I'm just going to give a few minutes. And you and I probably talk for a long time, but maybe we'll talk for about 10 minutes and take 5 minutes worth of questions.
Great.
Does that sound good to you? Okay, all right, great. So in some respects, you started off with faith. And I want to ask about faith, but maybe in a different way, because as I understood your remarks, the thought that came to mind is a crisis of faith. A crisis of faith about faith itself, right? Faith institutions. A crisis of faith in the institutional pillars of our democratic system. Financial, legal, judicial, social media, and maybe even, not just legal, but maybe even about law. So I'd like to invite you to reflect on that, if you will, and tell me, I might ask at the end, do you still believe in democracy? But how about at a law school where we teach students, where we teach civil procedure and the process of adjudication and its importance. Yeah. Do you still believe in law?
So let me go back to your crisis of faith point, which is we are having a crisis of faith across the board in this country, myself included. You know, I dreamed about being a civil rights lawyer from the time I was a girl. It seemed like the most amazing, wonderful, noble work to do, and I can tell you it has been that. But I certainly have been trying to create a world, you know, a world that I believe in. And, you know, I made sacrifices for that, right? You know, in trying to create this world. And I remember I would say to my kids as I dragged them to some march, you know, this is important, you know, for the future, and we have to be involved, and, you know, all that stuff. And this is a really sobering moment. So I think it's appropriate to have a crisis of faith. People talk to me all the time about, you know, young people don't believe in institutions. Well, what have we shown them that they should believe in? So the crisis is that we have to be worthy of the faith, you know? We have to actually create something that it's worthwhile to have confidence in. The reason that someone like me could have confidence in law is because of what Thurgood Marshall and Constance Baker Motley and so many others were able to do with it, right? But what I will say is here's where, you know, being a pragmatic advocate is really important. It doesn't matter whether I believe in law or not. It exists. And it is affecting the lives of the people that I feel privileged to represent. And so my job is to stand in the gap for them. We may be building something on the side that we think is better, but pretending that it's not real. And I know that this is happening in a lot of law schools. A lot of law students, and maybe some people in here, very much would rather kind of be community organizers. And I think community organizers is great. One of the things I wanted to do when I returned to LDF was build an organizing department, and I did. We have 7 full-time organizers on staff because I think it's so important, so powerful to the work, and such a check, you know, on us as lawyers, right, to make sure that we are connected and fulfilling the will of the people that we purport to represent. But you're a lawyer, and there are places only you can go, and things only you can do. And our communities need you. And it may not be the most romantic. You know, when I run down for people all the ways that LDF was involved in the civil rights movement, they're like, what? Get out of here. You know, it's like, we represented the Selma Marchers, we represented the Freedom Riders, we represented the Montgomery bus boycott, you know, and on and on and on.
And you didn't see LDF lawyers. You saw Dr. King, you saw John Lewis, you saw, right? So you saw the community organizers. It's a beautiful thing. But how do you think the march actually ended up happening? Right? It was Jack Greenberg and those other lawyers sitting on the hotel floor with, Hosea Williams and mapping out through and convincing the judge. Yes, it's going to be peaceful. Yes, we're going to have enough bathrooms. Yes, we're going to, that's what had to happen. So, you could be romantic if you want to, but if you are serious about representing marginalized communities, then you understand that you are needed. And there are things that only you can do. And so I worry a little bit that, in critiquing law, you got to be able to do two things at once. I always talk about Thurgood Marshall when he was litigating the Sipperwell versus Fisher case, which was a case challenging segregation at University of Oklahoma Law School. And he had a hearing down in the courthouse, federal courthouse in Oklahoma, and they finished up for the day, he and Ada Sipperwell Fisher, and actually she told me this. I called her cold when I was leaving LDF, and she said at the end of the day, she said, we had come and we hadn't realized we wouldn't be able to eat in the cafeteria. And at the end of the day, Mr. Marshall said to me, okay, well, tomorrow I'll keep trying the case, you bring the bologna sandwiches, and they had a little chuckle. Well, it's not actually that funny, when you think about it, right? So here he is, the lawyer, who cannot eat in the cafeteria. If it were me, there would have been a separate march. It's March on Washington, But he didn't, he kept it moving, right? He kept it moving and he won that case in the Supreme Court. So, I think there's this role for lawyers that is often not seen as the most romantic part, But the way we make change, certainly in this democracy, and the moments when we have been able to make the most transformative change is when three things are working in alignment. That is when there's grassroots activism, when there is terrific civil rights lawyering, and when there is political will. Right? And that's what we had in the civil rights movement. For a brief period of time, all those three things were happening at the same time. Now, I don't want to romanticize it, because that's the other thing. People saying, because we are in the civil rights movement right now, even though you don't realize it. It's not like people who were in the civil rights movement were saying, we are in a civil rights movement. They didn't know that till later, when the term was coined, okay? But what it means is that there is a time of turmoil and transformation when people are reimagining what their world, what their country can be. And that is precisely what's happening now. So if people are feeling a crisis, that's fantastic, because that's the beginning of the reimagination. It's not just reimagining public safety, which is actually happening in real time around policing. It's reimagining all these different elements, reimagining politics, I hope. So I think that we should be okay with the unease that we're having in the moment. It means that we have been revealed, that we have revealed ourselves to ourselves, and sometimes that happens. I've talked about the video of, and the snapshot actually, of George Floyd being killed and the officer with his hands in his pocket, and how that was such a mirror of our country. And we've had those moments. It's seeing the face of Emmett Till. It's this moments when we can see it. It's CBS breaking into the showing of Judgment at Nuremberg with breaking news in 1965 and putting those images from the Edmund Pettus Bridge, on our televisions on a Sunday night. Like, there are moments that stir things up and make us unsatisfied. And that's the beginning of transformation. So I feel okay even about my own misgivings and concerns. But what I do know is that this legal system is here right now. And it is snatching lives and is undermining livelihood. And it can be a tool for change. And we have to use it. We have to use it.
If you wouldn't mind, take a couple questions from our audience, and then before we wrap up, I have lots of things to talk to you about, but let's invite some folks to jump in. Thoughts? Yes.
When you're imagining new and innovative tools for change, how do you get the confidence to see those things through and carry them forward?
Oh my gosh. this is where the history piece comes in, and I do, you know, I am something of a legal historian, certainly of civil rights history.
You're very good historian of civil rights history.
I mean, two things. The first and foremost, the most obvious thing is, you know, if you are a intellectual and professional child of Pauli Murray and Thurgood Marshall and Constance Baker Motley, you cannot help but be in awe of the fact that, you know, Charles Hamilton Houston, they were creating something that they had no reason to believe could succeed. You know, there was nothing in 1940 when LDF was created that would make you think, yes, we can end Jim Crow. I mean, what were the signs that they're, you know, I mean, no. These were not people who were operating from a blueprint. They hadn't seen what they were trying to create anywhere else. They weren't saying, we want to be like France, or we want to be like England. They were creating something that didn't exist. So the first thing is the confidence of those people constantly inspires me, right? Number one, there were no signs it could succeed. And number two, they weren't following a guide. They were working together, they were consulting with the best in the field, they were pulling together a community of like-minded people, and they were doggedly using the system and hoping at every turn that it would work, and there was no guarantee that it would. Secondly, a week after the 2016 election, I had a previously scheduled public talk at University of Maryland, the undergraduate school, with Taylor Branch, the great civil rights historian, and Isabel Wilkerson, the author of The Warmth of Other Suns and Cased. It was a somber night. This is really days after the election, and you know, I was trying to put a game face on, but you know, it was tough. It was really tough. And Isabel Wilkerson is a truth teller, and a bit of a Cassandra as well. And she said, because I tried to say, but this is a moment when we can you know, I was dancing as fast as I could to try to, you know, put a good spin on what I thought we could do, but I really wasn't sure at that moment. And she said, no, Sherrilyn, you know, with respect, I think we are entering the nadir. And nadir was this period of time, you know, is it Rayford Logan, you know, said was the worst period for black people in the end of the 19th century, you know, beginning of the 20th century, where, you know, where black people were subject to lynching and little economic advancement and so on and so forth. And I kind of knew she was right, but, you know, I played it off and I said, what, really, why, you know, and I tried to, you know, and then afterwards I was like, God damn, you know, she may be right. So, but my instinctive reaction was, so what did we do in the nadir? And so I started to study that period. And I think it's important because I do think that we fool ourselves if we think that, you know, Plessy versus Ferguson happened in 1896 and then Brown happened in 1954. You know, what were people doing in the in-between period? They were doing stuff. They were trying things that didn't work. There was the union, you know, cooperative movement. There were all kinds of things they were doing that, and they were still fighting. They would bring cases that they were losing, and they were, you know, so that fight was still happening in that period until they found some traction. And, but the most important thing that was happening in the nadir was the building of black institutions. This is when the NAACP was created. A lot of our HBCUs were created and strengthened. A lot of black churches were created and strengthened. The sororities, the fraternities. The lesson is you just keep going, even though you don't know what the outcome is going to be. It's not so much the confidence, it's that something's going to take, and you just have to keep moving forward. There is no throwing in the towel in this thing. And so that's what keeps me inspired, and I think about those people with no guarantees of what the outcome would be, and having to navigate in ways that, you know, I didn't have to navigate. I didn't have to figure out whether I could eat in the airport coffee shop, or where I had to sit, or what hotel you all were going to put me at, or like, I didn't have to do any of that. And they had to do that, and they were able to somehow navigate and figure out this thing. And my awe and respect for those people very powerfully keeps me moving forward. It doesn't even have to be the most heroic. It's our parents and our parents' parents, and just what they did and couldn't have imagined. those are the things that I think we have to kind of hold on to in this period so we don't get discouraged. And I think we have been incredibly powerful. I'm very proud of how we navigated the years, particularly 2016 to 2020. We were amazing. And these were some of the best moments for our profession as well. There were some of the lowest, but there were some of the best. Our profession was extraordinary in holding back as much of the tide, the anti-democratic tide, as we could, and being bold. It was not an easy decision for me to have, LDF sue cabinet members and sue the president. We never sued the president before. But it had to be done. Not just for fun, but because, in the past, the people who were violating the rights of our clients were most often state governments, municipal governments, corporations, not the federal government. Now it was the federal government. So what do we do about it? We throw in the towel and say, we're not going to fulfill our mission? Or are we going to fulfill our mission? And we knew that we were dealing with a president who was likely to be vindictive. And so it wasn't easy. And we had to do all kinds of security things because we knew any morning you could wake up and if you were in a tweet, it was a wrap. So we were making decisions that were quite bold. I mean, I talked to, our litigation director all the time about the Saturday morning. I called him up in 2020 and said, I think we have to sue the post office. I love the post office. They had just given the Gwen Ifill stamp, literally 9 months before. And I was like, damn it, But the ballots have to be delivered. We had encouraged.
With Gwen Ifill stamps on them.
With the Gwen Ifill stamps on them. We had encouraged Black people to vote absentee. Remember, we were in the middle of a pandemic that was disproportionately affecting our community, and particularly people who were elderly and who had pre-existing conditions. And so we had encouraged people to vote absentee, and now their ballots weren't going to get delivered. It was a sacred trust. We had to ensure that the post office was doing its job and delivering those ballots in time to be counted. So we sued the post office, and we were successful. And that's, Sam would be in hearings, all day, 8 hours, on Zoom with Judge Sullivan, and we painstakingly had to make sure, because the postal workers were great. They were fantastic. But they needed the right, orders from above and conditions to be able to get those ballots delivered in time in different jurisdictions, because some jurisdictions would accept ballots, a few days after election. And so it was painstaking work. So it may not be front and center what happened in 2020, but just trust and believe that to the extent, particularly in those close races, LDF making sure ballots were delivered was huge. But it wasn't a comfortable thing to sue the post office. I mean, I think we had sued them before, like for racial discrimination in the 60s in employment. But we that wasn't a comfortable thing. It wasn't comfortable to sue the president under the KKK Act, but if the act fits, So I just think it takes a certain level of boldness and a willingness to use the tools that are available to you. And this is one of the problems I think we have in this country is, people say law doesn't work. We don't actually use all of it. We don't even use all of the Constitution. And I'm doing a project right now on the 14th Amendment, that focuses on this. We have a section of the 14th Amendment that says that people who participate in insurrection shall not serve in state or federal government. It doesn't say if and when. It says they only can serve if they overcome this disability by a vote of 2/3 of the House. So that means they just don't serve. We're not doing anything with that. It's just sitting there. And yet the framers, who had just come through a civil war and understood what insurrection was about, put it there to say, you cannot have these people in government. It's dangerous. And yet we're not using it. So when people say, oh, law, oh, Constitution, I'm like, well, before we throw the whole thing out, is it us? Is it our failure to actually use the tools that are, the 14th Amendment also contains the section that it says, if jurisdictions refuse to let, at that time, black men vote, that you can reduce their representation. Do we use that? We have all this voter suppression? No, we're just in there litigating all the time, exhausting ourselves. But Congress, which the framers of the 14th Amendment gave the power to enforce the provisions, are they using it? No. But we want to tell ourselves that it's all about law, it's all wrong. No, it's that we don't have the will to even use all the tools that are available. And that's was the great story of Charles Hamilton Houston and Marshall, is that they used what was there. They didn't make new law. They didn't make any new law. We didn't get any new laws until 65, 64. We didn't have any new tools. They did Brown with the same old tools that have been sitting there all the time. So I'm not sure that we can comfort ourselves with the idea that, oh, you know, it's not law, it's just activism. Again, confronting our own lack of courage, our own lack of scholarship, our own lack of will, our own failure of innovation. We have to be honest with ourselves about who we are in this process and who we have been, especially as things are likely to get worse.
We could do this for days. First, thank you once again to our dean for making all of this happen. So please join me. But of course, thank you most fundamentally to Sherrilyn.